Hi my dear friends, you may have already seen in the news that the new income tax bill of 2025 proposes allowing of WhatsApp messages as evidence during search and seizure proceedings of the Income Tax Act. Let us try and understand what was the legal position before and what is the legal position now and what would the legal position be in the near future. Let's forget about the new income tax bill. As of now, can WhatsApp chats be used as evidence in the court of law? Information Technology Act of 2000 allows this, and it is also supported by Section 65B of the Indian Evidence Act. The Indian Evidence Act says that you need to produce something called as a 65B certificate, where the owner of the mobile device says that yes, I am the owner and the screenshots are not tampered with, and the authenticity of the device and the integrity of the entire messages have to be certified. That's why screenshots are definitely allowed. But there's an exception to this. Instead of sharing screenshots, can I produce the mobile itself in which the original WhatsApp chats are stored? Yes, you can do that. So if the original device is produced, then the 65B certificate is not needed. A landmark decision by the Rajasthan High Court which came this month, Giriraj Pugalia versus Assistant Commissioner of Income Tax, the court upheld using of WhatsApp messages also, screenshots also, which are corroborated by substantial evidence. So during a search operation at the Om Kothari group, they found these WhatsApp chats where they have told that we have given you cash. This is the entry written in that statement. Pictures of the cash book, which is called as a black book because it's unaccounted money, and all those chats were corroborated with actual physical evidence when they did the raid. So this was presented to the court, and in a landmark decision, which again underpins the exception under 65B of the Indian Evidence Act, they said yes, I will allow this because the WhatsApp chats and the physical evidence are matching. Beautiful landmark decision. Second question, can I intercept WhatsApp messages in real time? One terrorist is stupid enough to message the other guy, chalo bhai aaj kuch tufani karte hai. There's a perfect section in the Information Technology Act, section 69, which empowers the government to intercept any message which is in the interest of sovereignty, public order, and to sort of catch the criminal activity. But obviously this requires a written authorization. But even with the written authorization, you need to have the device in front of you to intercept, or you need to ask WhatsApp to break the end-to-end encryption. Now this is the problem. Can WhatsApp break end-to-end encryption by the order of the government? So in end-to-end encryption, the sender and the receiver, that both can see the messages. Even WhatsApp cannot decrypt those messages which are stored in their servers. So in February 2021, the government imposed the IT rules of 2021, whereby WhatsApp, Facebook, Twitter, Instagram, all these people had to trace the originator and then ensure that the message was flagged down in 36 hours. And they had to maintain the traceability and records for 180 days. So WhatsApp filed a petition with the Delhi High Court saying that this is a blatant violation of Article 21, right to privacy. And they also quoted the landmark K. Puttaswamy case of 2017. Tracing the originator results in mass surveillance. Does government have the power to do mass surveillance? Government's contention was we are doing this to protect women, protect children against sexual abuse, protect the country against terrorists, etc. And they told WhatsApp that you have to develop certain tools to ensure that without reading those messages, you are able to decrypt these messages on a case-to-case basis. WhatsApp said that is not possible. So despite being one of the largest platforms in the world, the government threatened them that they would not get the protection of safe harbor rules. Now what is this safe harbor rules is the next question. Without this safe harbor protection under section 79 of the IT Act, WhatsApp will be held liable for all the content anybody posts on the platform, whether it is WhatsApp, YouTube, Facebook, Instagram, anything. So if some random person posts something on these social media platforms, the liability will not just fall on him, but also on WhatsApp. The platform is considered as an active participant, which is deadly. Through those rules, the government asked WhatsApp to redesign its entire architecture. And when they said it is not possible, they said your safe harbor protection under 79 will not be applicable to you. This case is still pending in the court of law. Even the Digital Personal Data Protection Act, called as the DPDP Act, also allows WhatsApp as evidence provided it fulfills the principle of necessity. Now, the new clause 247 of the Income Tax Bill 2025 gives power, unbridled power, to income tax officers to access and to override the controls with respect to your computer devices, mobile phones, and virtual digital spaces, which means your Google Drive, your cloud storage, and everything under the sun, Facebook, WhatsApp, Instagram, everything, if they have reason to believe that the individual possesses unaccounted cash or unaccounted income. Nirmala Madam in her speech also told that till now already almost 90 crore worth of crypto assets have been discovered through WhatsApp chats, almost 200 crore of bogus bills have been unearthed, and also 250 crore worth of unaccounted money by illicit syndicates have already been recovered through WhatsApp chats and the necessary corroborative evidence. So this would definitely act as a shot in the arm for the government and the income tax department to unearth black money. So in conclusion, in Bengaluru lingo, just use WhatsApp to come off for beer or put one scene, but not to reveal your cash or to put one line of hash.